Hello everyone, my name is Emily Atwood and I will be presenting on the topic of competence to waive the right to counsel and represent oneself in court from Chapter 7 in the textbook Psychological Evaluations for the Courts. A few objectives we will be covering in this presentation are: what is decisional competence? Why is the competence to waive the right to counsel important? And a few prominent cases dealing with waiving the right to counsel. I also provided a short video giving a few tips on how to represent yourself in court, as well as a discussion question at the end of this presentation. Before we dive in, it is important to note that decisional competence is very important when dealing with waiving the right to counsel. The textbook definition states that decisional competence is the competence to make a particular decision. The textbook also states that it is widely known for making decisions for individuals who are unable to care for themselves, which is known as parens patriae. This means to stay as parent, and is not allowed unless a person is incapable of making specific decisions or performing specific acts at issue. Decisional competence isn't just about waiving the right to counsel, it's about litigation, competence to consent to search and seizures, to exercise and waive rights to avoid self-incrimination, competence to enter pleas, and competence to refuse an insanity defense. But in this presentation, we will be discussing the competence to waive the right to counsel and to represent oneself. The decision to waive right to counsel may have adverse effects. This is because you are depriving yourself of a trained legal advocate. When a defendant voluntarily goes to trial without counsel, the defendant will be assessed about their abilities to perform basic tasks. This means that they are making sure that the defendant can communicate, testify relevantly, and provide reasoning to waive counsel, and they will be able to proceed without counsel if they can effectively carry out those tasks. The Sixth Amendment is also important when dealing with competence to waive the right to counsel. This slide presents a short portion of the textbook that states that the Sixth Amendment guarantees defendants the right to self-representation. It states that counsel is an assistant, however, an expert, it's still an assistant, and that it is an aid to a willing defendant. Continuing on about competence to waive right to counsel and to represent oneself, when being evaluated for competence, it's unlikely that they are testing for competence to waive right to counsel and to represent oneself, because it is unlikely that a defendant is going to decide to go pro se. If an evaluator is asked to do such an assessment, they typically complete a traditional competence to proceed evaluation, with the addition of making sure that the defendant is well aware of the disadvantages of proceeding without counsel. They should also go through lengthy examinations about the tasks attorneys go through throughout the trial process, as well as why the defendant decided to go pro se. If an individual decides to go pro se because they disagree with their lawyer or believe that they could do a better job, they are unlikely to be found incompetent unless their reasonings are tainted by mental disorder or disorders. Experts evaluating individuals who decide to go pro se often focus on assessing concentration, reasoning, and communication, since courts have not come to a uniform definition of competence to proceed without counsel. Now I will begin discussing a few cases that had substantial impact on competence to waive right to counsel. First, we will begin with Ferretta v. California. The Supreme Court ruled that the Sixth Amendment guarantees the right for defendants to represent themselves in court. Justice Stewart also stated that procedural rights of due process belong to the accused, not to counsel. Another thing that Ferretta v. California stated was that the court did not attempt to define competence to waive counsel. It also stated that not understanding technical legal matters does not mean incompetence when it comes to competence to waiving the right to counsel. The next main Supreme Court case mentioned in the text is Godney versus Moran. This court case found that competency to stand trial, plead guilty, and to waive the right to an attorney are the same. It's also stated that majority found that competency to waive the right to counsel is the competency to waive that right, not the right to represent oneself in court. Another main point is that the trial judge must know that the defendant's waiver is voluntary and knowing. This means that the individual must know the disadvantages of self-representation in court. Like I stated earlier, waiving this right is depriving yourself of a trained legal advocate and can cause more harm than good. McCaskill v. Wiggins is the next court case I will be discussing in this presentation. This court case states that if a defendant does waive the right to counsel and proceed to trial, they are authorized to be appointed standby counsel. It is stated that an individual will not be forced to proceed with this counsel as long as the defendant keeps control over the case. Standby counsel can provide advice and information about legal rules to a pro se defendant when conditions call for such action. The last Supreme Court case I would like to mention in this presentation that played a great importance in competency to waive the right to counsel and to represent oneself in court is Edwards v. Indiana. 14 years after Godney v. Moran, the court stated that if an individual suffers from a severe mental illness, they may be required to accept counsel to ensure fairness and dignity. However, in this case, the court declined to clarify about competence to waive counsel, but who is incompetent to represent oneself in court. This may be a cause for some confusion because there is still no set definition of what incompetence to represent oneself in court may be. In this slide, I have linked a short YouTube video on tips for representing yourself in court, also known as pro se representation. It is stated that formal hearings are governed by rules of evidence, which is a complicated topic, which is why it is important to have formal representation when going in front of a judge. It is important to know what you're doing when representing yourself in court, and this is something that takes many years of practice to master. So many individuals fail to accurately represent their case in front of a judge. If you'd like to hear more about it, feel free to check out this video I have linked. This slide is the discussion question section of this presentation. What risks may an individual face if they waive their right to counsel and decide to go pro se? Why do you feel this way? Make sure to support your answer with material provided throughout the textbook. Lastly, these are the references provided for my PowerPoint presentation. I hope you guys learned a little bit more about competence to waive your right to counsel and to represent yourself in court. Thank you all for listening to my presentation. I hope you enjoyed.